to unmute yourself and want to drop a question in the chat. I try to do a good job of keeping an eye on those and not missing those as well. Obviously, everyone's participation in enabling the mute function for themselves is the most important. Make sure that we all get the best audio and video recording without having to interrupt ourselves. Looking through, everyone's muted. Last call for any recording requests. Okay. AG, if you would like to unmute yourself and get started.
Can you hear me? Can you hear me?
I can hear you,
AG,
AG.
you sound good.
All right. Well, despite the judge's disappointing ruling today and her remarks to the contrary, today's case was actually quite a simple one. On December 14th of 2020, a group of 16 people entered the Michigan GOP headquarters with a mission to sign and mail a document to the United States Senate, falsely claiming three things. One, that they were the duly elected and qualified electors for the state of Michigan. Two, that they convened and organized in the Michigan state capitol. And three, that Donald J. Trump had won Michigan's popular vote. Now, we know that all three of these things were lies, and they did too. How do we know this? Well, they knew that the State Board of Canvassers had certified the election for Joe Biden. They knew that no recount was ever requested by the Trump campaign. They knew that they had lost every court case that had been filed in Michigan and across the country contesting the election. They knew that the legislature, specifically then Speaker of the House Lee Chatfield and then Senate Majority Leader Mike Shirkey, had refused to convene in an attempt to change the election results. They were very clear about that. They met these false electors, not again in the Michigan Senate, where the electors have to meet to vote under law, but in the basement of MIGOP headquarters, where they were made to hand over their cell phones to be placed in a bag and where they took an oath of secrecy for the event. They formally replaced the two Trump electors who did not appear, one of whom was the former Secretary of State, Terry Lynn Land, who knew this to be an illegal proceeding and so did not show up. They signed a document that specifically stated that they were actually in the Michigan Senate and that the time was 2 p.m., which they had to, of course, known to be untrue. These documents, we know, were then transmitted to the National Archivist as well as to the United States Senate with the intent that the false slate be substituted for the legitimate Biden slate. And that had Vice President Pence selected this slate, Michigan's 16 electors would have wrongfully and fraudulently gone to Donald Trump instead of Joe Biden, who won Michigan by over 154,000 votes. Some of these people had been actual electors in the 2016 election and had to have known that this was not the proper procedure. One of the people was the Michigan GOP party chair. Another was a municipal clerk of a large Michigan city, both who had to have known that what the actual rules were and specifically sought to circumvent them in a desperate hope that these 16 individuals could upend the votes of over 5.5 million voters in our state. And at times they even admitted that. Evidence was presented, for instance, that on December 5th and 6th, Amy Fraccinello and Michonne Maddock had a Facebook Messenger conversation, which was presented to the court. Amy asked Michonne, quote, "Have you received any communications about being an elector? I have not even gotten a letter or a single phone call. I have zero idea what is happening." To which Michonne Maddock responded, "Well, We are no longer electors, unfortunately. Only if the president had won Michigan, the Biden electors will be brought in. Um, you had many other statements that were made during the course of this conspiracy that should have been enough to show exactly that these individuals knew what they were doing and had the intent that was required to show that they had committed multiple different crimes. They knew they were not electors. They knew they were not inside the Capitol. They knew Donald Trump lost, but then they lied anyway. And that is a crime. You take these social media conversations and these posts and you apply them to any other crime, and there would be overwhelming evidence to support criminal charges. Now, it's been claimed that these charges were vindictive or political. And I will say this, nothing can be further from the truth. As prosecutors, we have a moral and ethical obligation to bring charges when there is evidence of a crime. And despite today's very wrong decision, the evidence is clear and overwhelming. And to not have brought these charges in the face of these facts because it would have been controversial or met with political accusations would really actually be the most political thing a prosecutor could do. So why do these charges matter? I mean, if these defendants had knowingly written a bad check, that is the crime of uttering and publishing all day, every day. I have prosecuted hundreds of crimes like that. Had they forged signatures on a petition, that's election law forgery. Had they signed documents falsely claiming another person's identity, that is a forgery. My office and prosecutors all across the state routinely charge these types of cases with far less fanfare and condemnation than this case received. And unfortunately, it's as true today as it was on December 4th of 2020 that for many, when it is this president and this president's followers, then there is no criminal activity, no action nefarious enough to warrant consequences of any kind, especially when it comes to rigging the system in Trump's favor. We saw it when he pardoned the January Sixers, where 5 people died, mainly police officers, more than $2.9 million worth of damage inflicted upon the U.S. Capitol. Many carried firearms, knives, pepper spray, baseball bats, or flags, which they festooned into weapons. In all, 1,575 people were charged, 418 for assaultive or violent actions, and yet each and every one of them was pardoned. Even the ones who pled guilty in their cases, the ones who caused massive destruction of property, even the ones who were sentenced to prison time for attacking police officers using improvised weapons like flagpoles or fencing. We saw it when the highest court of the land, the United States Supreme Court, granted Donald Trump immunity for any and all actions as president of the United States, despite being indicted for inciting that very insurrection, as well as a multitude of other crimes. And we see it in this term of office as well, when the president defunds the U.S. Cybersecurity and Infrastructure Security Agency in charge of keeping foreign interference out of our elections. We see it when he places the head of that agency under investigation for what? For simply stating the factually accurate conclusion that the 2020 election was not stolen. We see it in his flagrantly illegal executive order from March of this year, when Donald Trump attempted to illegally usurp states' rights to run their own elections and impose federal standards, or when he takes steps to eliminate mail-in voting, despite being a routine absentee voter himself. It's present in the White House when he shows off his Trump 2028 merchandise to world leaders as though the 22nd Amendment is a mere suggestion. And we see it in the courts in real time today as judges in Michigan and across the nation hem and haw over these election-related cases. And it's getting harder and harder to even get an election case across the finish line, let alone to get them in a timely decision where perhaps it would have made a difference in people's actions later had there been more responsibility provided at an earlier time. And I think In large part, that's because of the fear of retaliation and the ongoing intimidation of threats our judges receive when presiding over cases in which the president has a stake or even just an opinion. This is the most dangerous, slippery slope that exists for American democracy. When the courts determine that violations of election law should not even be heard by a jury, when state legislators and governors across America make it easier for Trump to cheat, when the Supreme Court hands the president a blank check to violate any law, commit any crime without penalty or consequence. I am terrified for the 2026 elections. And not because I'm worried somebody I support will lose. I'm worried that President Trump and his aiders and abettors and followers have already ensured that no future American election will ever really be fair or free. That's why we filed these charges, not only hopefully to effect positive change, which I believe we have through Congress's new rules regarding the submission of electoral slates, but to serve as a warning that in Michigan, we will make any and all efforts to ensure that people who attempt to criminally interfere with our elections are held accountable. In this case, we aren't discussing one person who voted twice or one person who voted and should not have been eligible to do so. We are talking about 16 people who conspired to nullify the votes of the other 2,649,851 voters who happened to disagree with them. The evidence was clear. They lied, they knew they lied, and they tried to steal the votes of millions of Michiganders. And if they can get away with this, well, what can't they get away with next? This was, in my belief, a coordinated attempt to overturn the will of the American people and reinstate Donald Trump as president. Despite Joe Biden's victory in the election to that office, this was the boots on the ground effort necessary to effectuate a modern American coup, a stake through the very heart of our democracy. We saw that scheme play out, and the plan was clear as day. Send a false slate of electors to Washington, D.C., and count on Vice President Mike Pence to refute the legitimate Biden electors, citing Trump's false and ironic claims of fraud, and instead count these Trump electors to flip the results of the American presidential election in the Electoral College from Michigan and from several other swing states as well. That this plan ultimately failed, very nearly at the personal cost of Mike Pence's own life, does nothing to diminish the insidious attempt to overturn the election, betray the American voters, and end democracy in this nation founded on the very ideal of self-governance. It was an attempt to pierce the very heart of what makes America, America. This plan fails without these defendants being willing to ascribe their names to this false certificate. And for all the president's lawyers and schemers and sinister loyalists, they could not themselves fulfill this duty. And they needed people such as Burden, Maddox, Sheridan, Choate, Facinello, Frost, Grott, Haggard, Henry, King, Lundgren, Rodriguez, Rook, Thompson, and Vanderwood, who would be willing to sell out American democracy just to keep their candidate in office. When I complete my time in this office, I will forever believe that issuing these charges and filing these cases was the righteous, proper, appropriate, and legally compelled thing to do by my role as state attorney general. And I feel certain that history will vindicate that decision.
Thank you, AG. I'd like to open it up to AAG Kayla Crino and Criminal Justice Bureau Chief Daniel Hageman Clark to share remarks. Daniel?
After hearing the AG speak, I have nothing further to add to that. Thank you for the opportunity, though.
Thank
Kayla?
you. Thank you, Attorney General. I just have one thing I want to address. As a prosecutor and as one of the advocates in this case, it was my duty to seek justice. And that is exactly what we did here. And I just want to briefly address the issue of intent. It's really important here to remember that under Michigan law, the relevant intent here is the intent to impair a legitimate government function. And as to that intent, the fraudulent electors, they intended two purposes for their fraudulent certificate. Before signing, the group was advised of two purposes for the document. The first was that the document would be presented at the state capitol along with the true Democratic slate of electors that same day. It was not contingent on Trump being declared the true winner of the election. The group was told that the representatives and senators had the ability to accept their slate of candidates rather than the true electors, but that it had to be done by 2 p.m. This purpose was not contingent and it would happen that very day. And this purpose also aligned with the actual language of the document, which was not contingent and directly impaired a legitimate government function. And this is what the court previously had to say about that. My understanding of what he just said, and he is referring to Renner, was that there were two reasons this one document, not two documents, were used. One, that they were going to send it off to the Senate that day, and that the Senate would make a determination as to which they were going to use. And then that same document would be used contingently if there was a recall. And it is this non contingent purpose for their fraudulent certificate to be used rather than the legitimate certificate that demonstrates their intent to impair a legitimate government function. And so that was the only thing that I wanted to add to the Attorney General's remarks, is that it's critical to not lose sight of what the relevant intent that is actually applicable in Michigan law is.
Thank you, Kayla. With that, we will open it up for questions. Again, I ask that you please raise your hand, and I will call on you and ask you to unmute. So with that, Craig Mugger from Detroit News, we'll start with you.
Attorney General Nessel, you described this as a coordinated attempt to overturn the will of the people. Do you have any regrets at this moment about bringing charges against some people who were maybe or maybe not knowledgeable about what they were doing, showed up and signed a document, and not bringing charges against the people that were actually doing the coordination? Thank you.
Yeah, we bring charges against those where we have the sufficient evidence to move forward and to prove those charges, and where we have legally admissible evidence in order to prove those charges. And that is why we brought the cases that we did against the defendants that we charged, and why in other cases, individuals who may have also had culpability were not charged.
Jordan Hermany, I'm going to ask you to unmute and lower your hand.
Hi, thank you. I just wanted to kind of follow up on Craig's question there, where you had mentioned a moment ago that, quote, no action nefarious enough to warrant consequences of any kind when it comes to rigging the system in Trump's favor. I believe it was Howard Schock on the stand who noted that Donald Trump was an unindicted co-conspirator in this case. If it's believed that, these 15 individuals, they didn't do enough to bring this case to trial, why not charge the president if we believe that there are serious improprieties going on here with how this case played out?
Yeah, well, many times you receive information about the actions of a particular individual, but it doesn't mean that that evidence is admissible in court. And so there are times where you have people that you know they are co-conspirators, but it doesn't mean that you have the evidence necessary to file that case.
Thank you. I'm going to give it to Kyle Davidson with Michigan Advance next.
Hi, thanks so much. Attorney General, I just kind of wanted to keep following that train. I wanted to check in on the status as far as this investigation. Does that remain open? And, I guess kind of given these circumstances, is there even the possibility of additional individuals facing charges?
I find that to be highly unlikely given the circumstances that we are facing now. I do want to repeat, I personally feel as though this evidence was overwhelming and that we presented that evidence to the court. But I will say this, by and large, if you look state by state, irrespective of the fact that we know that there was this grand conspiracy, and there's almost no questioning it that this conspiracy existed. We are just not seeing accountability in the courts, either here in Michigan or any place across the United States. And as I said earlier, I find that to be deeply troubling. But do I believe, given these circumstances, that any additional defendants or additional charges are likely to be successful? Unfortunately, I believe that's not the case.
Thank you. Eric Heisig with Bloomberg.
Hi, thank you for doing this. This may be a knowledge gap on my part, but is there any chance of an appeal or any way to have a higher court look at the decision today?
There is a way to do that. We do have the right to appeal the judge's decision not to bind over the case, and we are evaluating that.
Okay.
I do.
Isabel, oh, sorry, go ahead, AJ.
No, this was not specifically asked, but there's a couple points that I want to make that I think it's important to know. Firstly, um, I believe that Judge Simmons erroneously indicated that somehow there is a constitutional right to seek these types of redresses when one disagrees with the election results with their senator, or a constitutional right to contest the election in the way in which they did. And I would argue that such a constitutional right doesn't exist. We have an election law, many different ways in which a candidate can contest an election if he or she believes there to be fraud or a mistake. And our election laws delineate that very clearly. And yet again, all of the actual cases that were filed were not successful. And if you look even at the language of the courts and some of these, remember, some of these individuals were actually defendants in this case. And you have in the case of, I believe it's King v. Benson, that the court saying, and this is a case that King, Sheridan, and Haggard were all plaintiffs on, the court finds that plaintiffs are far from likely to succeed in this manner. In fact, this lawsuit seems to be less about achieving the relief plaintiffs seek, and much of that relief is beyond the power of this court, and more about the impact of their allegations, people's faith in the democratic process, and their trust in our government. Plaintiffs ask this court to ignore the orderly statutory scheme established to challenge elections and to ignore the will of millions of voters. This the court cannot and will not do. The people have spoken. So again, this was not even a matter that the Trump campaign decided to contest via their right to have a recount. They didn't even ask for one. And then these particular defendants, some of them were involved in lawsuits where they heard from the judges themselves that there were no viable claims here. And I think that is part of why I find it so bewildering to say, well, these people didn't know. They had this constitutional right to try to circumvent the election by sending in this false certificate, even though they knew from the courts that that was not something they could do. And they knew from the statements, again, made by both the Senate Majority Leader and by the Speaker, that the legislature was not intending to do anything because of their belief that it would have been illegal for them to do so. So again, you know, when you combine all of these various pieces of evidence together in conjunction, of course, with the very lies that were contained within the document that they signed, we continue to believe that there is not just sufficient, but overwhelming evidence of guilt. And I believe if this matter were to go before a jury, that 12 individuals would come to the same mindset that they are guilty of the offenses that we charged.
Thank you, AG. Isabella Volmer with the AP.
Thanks, Attorney General. You said earlier that you worried that judges around the country are acting out of fear of retaliation when they're presiding over cases in which the president has a stake. Can you clarify? Do you believe that's what's happening here?
I'm going to say that I think that the threats to judges in our state and around the country are, an assault on our democratic process. And I think it's likely that in some circumstances, there are judges out there that think about the threats they've received. Think about how the immense power that this president has, and maybe sometimes decide it's not worth it to do anything that would challenge the president or to impugn him or his supporters.
Thank you. Jordan Hermany with Bridge again.
Hi, apologies. Separate line of question. While leaving the courtroom today, Representative Matt Maddock was very vocal about the idea of suing you in return for what he alleged was political persecution, political lawfare. I'm sure you've heard iterations of those kinds of comments before. I was just wondering if I could get your reaction to that sentiment.
I think any such lawsuit would be specious and be wholly lacking in viability and merit.
Thank you.
We have Steve Carmody with Michigan Radio.
Attorney General, unfortunately, my system glitched when you were asked about possibly appealing this decision. If you could tell me, what are the plans? Are you going to try to appeal this? Is it appealable?
Well, I mean, from a legal standpoint, is it appealable? Yes, it can be appealed. We are still reviewing the court's decision and we'll be making a decision at a later time as to whether or not we appeal.
Seeing no more hands, I thank you all for your time today. There was a few people who mentioned that they had some recording issues, so please feel free to email AG Press and we will get you a copy of this recording as soon as it is uploaded and available. For any further questions, please contact agpress@michigan.gov. Thank you all so much.